committee and the functionaries that accompany me from the Department of Transport, but also from the National Council of Provinces. The purpose of us finding ourselves in front of yourself as the Select Committee on Public Service and Administration, Public Works, Infrastructure, is to present to yourself the bill of ATNS as it's before you. The Air Traffic and Navigation Services Company, it's a state-owned company, limited, was established in 1993 through the ATNS Company Act number 45 of 1993 for the acquisition, establishment, development, provision, maintenance, management, and operation of the air navigation infrastructure, air traffic services, or navigation services. It is a public entity listed as in Schedule 2 of the Public Finance Management Act, number 1 of 1999. Honorable Chairperson, let me indicate the challenges that we and highlight the challenges that has brought about the amendment of this act. The bill seeks to amend the Air Traffic Navigation, Air and Navigation Services Company Bill of 1993 to strengthen the current economic regulatory framework. The current act is not aligned to the Public Finance Management Act of Act number 1 of 1999 and the New Companies Act, Act number 7 of 2008. The empowerment to amend the air traffic, empower the traffic and navigation systems is to provide the service outside of the Republic of South Africa as a subsidiary. The main objective being to ensure that investments outside of the Republic of South Africa are protected to avoid or minimize the risks that could affect the ATNS as a company. And lack of appeal mechanisms are some of the things that we are saying that in the eventuality there are parties in dispute, there has to be a decision by the committee. Approach to the document does not have a legal status since there is no empowering provision for the use of the approach document by the committee. Approach document is the committee's guidelines to the company for the submission of a permission application. The minister is not empowered also to make regulations on economic regulations, the procedure to be followed by the committee to enforce compliance, and the manner in which to be used to form or lodge a complaint or an appeal. Program Director, clause by clause, some of the issues that we have been able to look into and make as amendments are as follows. Clause 1 of the bill amends Section 1 of the principal bill by inserting certain definitions, that is the Airports Company, the Appeals Committee, Approach Document, Companies Act, Director General, relevant activities, subsidiaries, economic regulation, amongst others. The insertions of these definitions will assist with a better understanding of the Principal Act. Clause 2 of the bill amends Section 2 of the Principal Act to align the Principal Act with the Companies Act of 2008 by deleting references to the provision of Repeal Companies Act. Clause 3 of the bill amends Section 5 of the Principal Act and the period of publishing any airport charge by the company is extended. I beg, sorry, Chairperson, I was just cut off. Thank you very much. Clause 3 of the bill amends Section 5 of the Principal Act, and the period of publishing any airport charge by the company is extended by a month prior to that charge coming into operation. This reason is for the amendment is to allow the users of the air navigation services infrastructure, particularly the airlines and other operators directly affected by the new tariffs, sufficient time to prepare for the implementation of the new tariffs as issued by the committee. Clause 3 also inserts the paragraph G into Section 5, Subsection 2 of the Principal Act to ensure that any activity or business by other than the relevant activities, that is regulated business inside or outside the Republic, is provided by the subsidiary. ATN as a company will do so in a manner that will not substantially or adversely expose the core business or relevant activities to financial risks. Clause 3 also further amends the subsection 5.3 of the Principal Act to empower ATN as a company to venture into other businesses to increase its revenue from source other than air traffic charges or relevant activities. This clause supports the proposed new section 5 subsection 2G, which encourages ATNS company not only to rely on the income from the air traffic services or relevant activities. Clause 4 of the bill amends section 11 of the Principal Act by extending the period of amendment of the conditions of the permit and also giving the approach document a legal status. Section 11, subsection 2 is amended to seek the company to apply to the committee for issuing of permit by no later than last month of the fourth financial year, since the permit will be allowed to run for a full 5 years without amendments. The permission is reviewed after every 3 years, and the company is required to apply in the first 3 months of the third financial year. Section 11, subsection 6A is also inserted into the Principal Act to remedy the situation whereby when an existing permission lapses due to the delay in the issuance of the new permit of the new one, so that the ATNS company can continue levying airport tariffs. The delay are normally caused by the prolonged consultation between the committee, the company, and the user airline representative as a result of different views on the economic regulator decisions, that is tariffs, capital expenditure project, capex, operational expenditure, etc., etc. Clause 5 of the bill inserts new sections 11A and to section 11C into the Principal Act that provide for the appeal mechanism, including the procedures for the hearing of the appeals and the decisions of appeals committee, where the ATNS as a company or aggrieved person may appeal against the decision of the committee. The clause of the bill, clause 6 of the bill amends section 13 of the Principal Act by allowing for the manner in which an aggrieved person. Thank you, Honorable Chairperson. I was indicating that clause 6 of the bill amend Section 13 of the Principal Act by allowing for the manner in which the aggrieved person or the company may lodge the appeal with the appeals committee, either in writing on the prescribed form. Clause 7 inserts Section 13A into the Principal Act, which provides for offences and penalties, whereby any person who willfully. Honorable Chairperson, I think there's an echo. I don't know if it's coming from my side or your side, but let me continue.
There is a SB whose device is not muted, which definitely interrupts your presentation, DM. Our apology. I hope the IT people will be able to sort that matter out. You can continue.
Thank you very much, Honorable Chairperson. I was indicating that Clause 7 inserts Section 13A into the Principal Act, which provides for offences and penalties whereby any person who willfully disrupts proceeding, fail to attend the hearing as summoned by the appeals committee, fails to satisfy the answers to the questions put to him or her, or any person after being sworn in or having made affirmation gives false evidence, is guilty of an offence and is penalized accordingly. Clause 8 amends Section 14 of the Principal Act by authorizing the Minister to make regulations by notice in the Gazette after consultation with the committee regarding the matters related to economic regulation. The procedure to be followed in terms of the non-compliance by the company and the form to be used to lodge complaints with the committee. The Minister is also authorized to make regulations regarding the form to be used in the manner in which to lodge an appeal with the appeals committee. Chairperson, Clause 9 amends the long title of the Principal Act as a result of the amendment that will be incorporated into the Principal Act once the bill has been enacted. And Clause 10 amends certain expressions, citation, and words that will be used in the Principal Act by updating those expressions, citations, and words to reflect the present dispensation. Clause 11, Chairperson, is a short title and commencement, which is a standard provision dealing with the short title and commencement of the envisaged Act. Several stakeholders have been consulted in this regard. NEDLEG, ESAID, the Economic Sector Employment and Infrastructure Cluster, BARSA, AASA, ATNS, AXA, for concurrence, and I so present Comrade Chairperson that the bill be looked into and be by the Select Committee for Public Service and Administration, Public Works Infrastructure today, and there are Advocate Masumbuka will take honorable members into how we believe the bill will be structured. I would request through you, Chairperson, that I give to Advocate Masumbuka to can be able to take the leadership of Parliament into the bill as it will be presented to your good self. Thank you very much, Chairperson.
Thank you, Honorable DM, for laying the ground and the framework for Advocate Masumbuka to take the center stage. Over to you, Advocate.
Good morning, good day, honorable members. We are presenting two bills, which is the Air Traffic Navigation Services Company Amendment Bill 2018, and also later on we'll present the Airports Company Amendment Bill. The ATNS Principal Act, there was some discomfort from the companies and various committees that it is not transparent and predictable because it omitted a lot of issues in it. For instance, the challenges that are faced by the Principal Act or that are in the Principal Act are that the current legislation does not provide for appeals mechanisms. The minister is not empowered to make regulations regarding any matter related to economic regulation. The key features of the bill are as follows. It gives legal status to the approach document. The approach document is a historical guideline document which informs the companies on how to make or guide the companies on how to make applications for the permits. This document was not mentioned in our principal legislation, but it was used like when you are using regulations or the rules in terms of the Act. Now we want it to be referred to in the Act so that we can give it its legal force, so that when there is a challenge, a person must not say, approach document is not mentioned in there, but it's a document that is having a lot of guideline from the committee. So we have introduced the approach document as a guiding document on how to apply for permissions. The approach documents provides for guidelines to be followed by the companies when applying for their permissions. We are aligning the Act with the Companies Act. The current Principal Act is making reference to all sections of the Companies Act which are already repealed. And we are further also aligning it with PFMA. We provide for the procedure of the meetings and decisions of the committee to ensure transparency, flexibility, and predictability of the regulatory decisions. We provide for effective appeal mechanism in the bill. We empower the minister to make regulations regarding any matter related to economic regulations, procedures to be followed by the regulating committee, and non-compliance by the company. The proposed amendments are as follows. We have structured the presentation to provide for the problem as to what is actually the problem, and also how do we want to resolve that particular problem, or how are we resolving the problem in terms of the bill. The object of the company does not cover the mandate of the company to conduct business outside the Republic. And we are resolving that by amending Section 4 to make provision for that, that the company can make a business outside the Republic. The second problem statement is that the current period of publishing any air traffic service charge is 3 months. Now we're extending that particular period to a 4 months period. In essence there, what we are saying is that the air traffic service charge, if they are to amend, they must be published 4 months before they can come into operation, so as to give the companies and any other interested party enough ample time to prepare himself for that particular amendment. The third problem statement is a permission is valid for 5 years. However, the companies are required to apply for new permissions after 3 years. This provides rooms for gaming on the regulatory framework. The solution that we are proposing in the bill is that we are amending Section 11 to ensure that a permission is valid for a period of 5 years without interruption, with options to reapply within the validity period of 5 years only under material circumstances. Problem statement number 4 is that there is no dispute resolution within the regulatory framework of the Principal Act, and we are providing for that by coming up with Section 11A that provides for the appeals mechanism. Problem statement number 5, the forms that an aggrieved person or company may use in lodging appeals is not prescribed, and we are amending Section 13 to prescribe those particular fields when the forms that person must fill in when lodging an appeal. Problem statement number 6, there is no procedure relating to the conduct of any person attending proceedings of them. The solution is in the bill is by amendment of Section 13 by prescribing the procedure relating to the conduct of any persons attending proceedings of the appeals committee. Problem statement number 7, the minister is not empowered to make regulations regarding any matter related to economic regulation and the procedure to be followed in terms of non-compliance by the company. We are solving that by providing a solution in the amendment bill by amendment of Section 14, by empowering the minister to make regulations by notice in the Gazette after consultation with the committee and the aviation industry. The DM has already mentioned the stakeholders which were consulted closely in developing this bill are the Regulating Committee, the Airports Company of South Africa, the Air Traffic Navigation Services, the Airline Association of South Africa, ASA, and the Board of Airline of South Africa, BASA. Public consultation. The bill was published in Government Gazette on the 31st December 2014. The comments were scrutinized and later the bill was scrutinized and later certified by the Department of Justice and Constitutional Development. The bill was tabled in the National Economic Development and Labour Council NEDLAC on the 28th October 2016. The bill was supported by SIA's report on the 14th of February 2017. The bill was supported by the ESET cluster on the 15th March 2017. The bill was presented to and approved by Cabinet during May 2017. The bill was introduced in Parliament with reference B6 of 2018. The bill was introduced in Parliament with reference B5 2018, and on June 2018, briefing on the bill to the Portfolio Committee on Transport was done by the Department of Transport. On the 5 February 2019 to 12 February 2019, there was a briefing and deliberations on the bill in the Portfolio Committee. On the 12th March 2019, Portfolio Committee of the 5th Parliament adopted committee report on the bill. The bill was further presented to the PCOT on the 6th Parliament on the 11th February 2020, and discussion on the bill took place from 18 February 2020 to 3rd March 2020. The bill was passed by the National Assembly and transmitted to the National Council of Provinces for concurrence. In short, Chairperson, that is the gist of the bill, and we request the support of the Select Committee in processing this bill further up until to its adoption stage. Thank you, Chairperson.
Can you take us through the second bill, and then when we deal with the questions and clarity seeking questions, we'll then deal with all the both of them.
Thanks, Chairperson. The second bill is the Airports Company Amendment Bill. Presentation to the Select Committee today. The Airports Company Amendment Bill 2018 seeks to amend the Airports Company to strengthen the current economic regulatory framework. Also, with regard to the Principal Act, there were some dissatisfaction by the companies that it is lacking, is having some gaps. Thus, that necessitated the amendment of the Principal Act to come up with this particular bill. The challenges to be addressed in the Airports Company Principal Act are as follows. The current legislation does not provide for appeals mechanism. The minister also was not empowered to make regulations regarding any matter related to economic regulation. Further, the key features of the bill are as follows. We are giving a status to the approach document, which I've already explained that it's a approach document is a guideline document which was not referred to in both principal acts, and is a significant document which gives guideline to companies on how to apply for permissions. We align the act with the Companies Act, like I've said, is still making reference to the old Companies Act as it was amended. We prescribe the procedure for the minister that the minister must follow when appointing members of the committee and the appeals committee. We provide for the procedure for the meetings and decisions of the committee to ensure transparency, flexibility, and predictability of the regulatory decisions. We provide for the effective appeal mechanism. We empower the minister to make regulations regarding any matter relating to economic regulation and procedures to be followed by the regulating committee on non-compliance by the company. The bill has also some problem statement. Number one, the minister, in the Principal Act, the minister does not have powers to disqualify committee members. Members are also not compelled to disclose their interest or vacation of office and termination of appointment of committee members from committee. It's not stipulated in the Principal Act, and there is no procedure for the meetings of the committee. The solution is by insertion of Section 11 11, capital A, capital B, capital C, capital D, capital D, and capital F, by empowering the minister to appoint and disqualify members of the committee, dealing with disclosure of interest of committee members. Here we are referring to a situation whereby the minister is making a selection of the regulating committee or the appeals committee. What are the factors which minister can take into account to say this member doesn't qualify to be a member of the committee or a member of the appeals committee? So in this bill, we are stipulating factors that might lead to a person not to qualify to be a member of either of the two committees. We are also indicating as to how can a person vacate the office. For instance, the need for a member who's already appointed to give a notice for termination of his service as a committee member. And also the termination of appointment and procedure for the meeting of the committee. Problem statement number 2, there is not dispute resolution mechanism in place. There is no clear procedure on how the decision of the committee should be handled in the Principal Act. Therefore, we are resolving that by putting new in session section 12, capital A, capital B, capital C, capital D, to establish the appeals committee and empower the minister to appoint, disqualify, and terminate the members of the membership of the office bearers of the appeals committee, and to also provide procedure for hearings, appeals, and to address how the decisions of the committee should be handled. To insert also section 12E, 12 capital E, capital F, capital G, and capital H to ensure that the appeals committee members are required to disclose their interest and there are clear procedures relating to vacation of office and termination of appointment. Problem statement number 3, any person who is aggrieved by the decision of the company should be empowered to lodge a complaint against the company with the committee. Solution, we amend section 14 by empowering any person who is aggrieved by the decision of the company to lodge a complaint with the committee. Number 4, the minister is not empowered to make regulation regarding any matter related to economic regulation and the procedure to be followed in terms of non-compliance with the company. We resolve that by amending section 15 by empowering the minister to make regulations by notice in Gazette after consultation with the committee and the aviation industry. Also here, the stakeholders consulted very closely or who participated in the development of this bill is the Regulating Committee, the Airports Company of South Africa, AXA, the Air Traffic Navigation Services, which is ATNS, the Airlines Association of South Africa, which is ASA, the Board of Airlines South Africa, which is BASA. There were further public consultation by publishing the bill in a Gazette for comments on the 31st December 2014. Bills were scrutinized and later certified by the Department of Justice and Constitutional Development. Bills were tabled to NETLAC on the 28th October 2016. Bill was supported by SIAS on the 14th February 2017. The bill was supported by the ESA cluster on the 15th March 2017. The bill was presented to and approved by Cabinet during May 2017. The bill was introduced in Parliament with reference B5 2018. On June 2018, a briefing on the bill was done to the Portfolio Committee on Transport, and it was adopted and transmitted to Select Committee for further processing. I thank you, Chairperson.
Thank you, Advocate, for the work in terms of elaborating further in terms of the ground that was set by the Deputy Minister. Indeed, what is emerging from the presentation, it's an attempt on the part of the department to strengthen number of problem areas that were identified from the appeals mechanisms to strengthening the regulations, but also to ensure that there is an alignment between the Act and also the Companies Act. Honorable members.
Chairperson.
The two, yes, Hlubeka?
Before you can give to members, I don't know whether maybe the legal advisor, the parliamentary legal advisor, would like to say something.
Yes. I think that let's do that. Let's probably allow the parliamentary legal advisor just to share some views and inputs with regard to what has been presented. Is it Camilla?
Fatima.
Over to you, Fatima.
Good morning, Chair and honourable members. Chairperson, we are quite happy with the bill as it is. The issues that we picked up in terms of some minor changes that we had suggested were all sorted during the portfolio committee process that went through the National Assembly. So all our concerns have been captured, Chair. So we're quite satisfied with what's been presented today. We have no further input.
Thank you, Fatima, for that guideline. Honorable members, I will now open the floor for engagement and clarification questions, discussion. I'm trying to check in terms of the raise your hands option. I've not seen any, but I think let's then open the floor. I've seen Honorable Khai. You can hit the ground running, Honorable Khai. The floor is yours.
Thank you very much, Chair. Unfortunately, I don't have the raise hand function. Thank you, Chair, and thank to the Deputy Minister and also Advocate for the presentation on the two bills. When I look at the two bills, Chair, they seem like that they are addressing similar issues. So, and therefore, my question maybe then going to both because the issues that the bills are trying to address are very similar. So I think the first issue, Chair, I would like to find out with regard to the amendment that would allow both entities to do business outside the Republic. What kind of business? What kind of business is it referring to? For both, that will be outside the Republic. The second question, Chair, is with regard to the committees. When there's a committee and also the appeals committee that the bills are referring to. One on the committee, the first committee, there's no indication as to the period for those that are appointed. For what period are they appointed? Because if you go further, for example, if you look at the airports company on the new amendment 11E. Is it 11E? It talks about the replacement of members of a committee, and therefore the appointment of the replacement. The person will then serve the remainder or the unexpired portion of a period for which that member was appointed. Yet the bill doesn't say anything about the period. Yet when you look at each vacation of office and termination of appointment, 11D, 2, it says the minister may, in accordance with section 11A2, in brackets, appoint a person to fill the vacancy for the unexpired portion of the period. Yet the silence in the bill about the period. So for me, that section therefore is irrelevant because it's not referring to a particular period, because we don't know how many years of this particular unexpired portion of a period, because it doesn't state how many years a person should serve as a committee member. The second part is on the appeals. Also on the appeals, it doesn't explain the period, but all it says is that the minister will determine the period for which the appeals committee is appointed. I don't know how that is going to be done, whether it will be in the regulation, this determination, whether it will be in the regulation. So if we could get clarity on what we mean that by saying the minister will determine the period for which the appeals committee is appointed. The next question, Chair, is with regard to the regulations. It says that the minister will be making regulation with regard to, I think, economic regulation. What I would like to find out, what is the role of the regulation committee? Also in relation to the economic, what is it that the committee is regulating that is different from what the minister will be regulating? Because in terms of the definitions, it talks about there's a definition on the economic regulation that relates to the issue of I think the cost. Let me just say, it talks about the price controls, the economic regulation in terms of the definition. So what is it therefore that the minister will be regulating in terms of the price controls? What is it that the regulation committee will be doing with regard to its work? Yeah, basically those are the few questions that I needed clarity on. Thank you very much.
Thank you, Honorable Khai. I've seen Honorable Rataseth. The floor is yours.
Thank you, Chair. Chair, are you able to hear me?
I'm able to hear you, Honorable Tim.
Chair, I'm sorry for not turning my camera on because I'm in a place with very low signal. Chair, I want to echo the questions that Honourable Khai asked. They are all very good questions and I'm interested to hear the answers. Chair, I've consulted with my portfolio committee colleagues and they are generally in support of these two bills, so we don't have any major hassles. I just want to confirm for this select committee where we are in the process. My understanding is that the matter may still serve before the portfolio committee and then still needs to go for a second reading to the National Assembly. So in effect, these bills are currently being revived. Obviously with these alterations and sticking points that have been sorted out. So if the colleagues in the meeting can just confirm where we are in the stage and when we anticipate the matter will then come back to the NCOP for our approval. And then secondly, Chair, just a comment that I was concerned about the minister becoming the de facto regulator, but I was advised that this is actually a good idea because if the services that the Department of Transport provide work well, there is no need for all of these various regulators like the PRASA regulator to be involved. So it's a step in the right direction that the ministry, that the regulation of all the various services actually falls under the department. Can the colleagues just confirm that that is the end goal? That in actual fact we try and get rid of and slow down all these various regulators that are involved in the transport sector. Chair, that I think is pretty much where I would like to leave it at this point. If I can just get some responses to those comments and those queries, I'd be grateful. Thank you.
Thank you, Honorable Tim. There's also question on the chat. Can we request the committee secretary to read the two questions from Honorable Matibula?
Thank you, Chairperson. The question I read as follows. Question to the Deputy Minister. One, whether the department will invest in expansion of aviation industry and airways in order to encourage more passengers to use air transport. Two, whether the bill will be open and transparent in making sure that the committee together with the appeals committee are appointed in a transparent manner.
Thank you, Hlubeka. Fatima, can you just clarify the question that Honorable Bratteseth posed? Can the
Chair, I cannot hear you very well. Can you please repeat?
Honorable Bratteseth posed a question about the process where we are with regard to these two bills.
Yes, Chair. If you look at the chat group, Chair, I've just posted a picture that will show you the whole process that's been followed thus far. I think the confusion may be, Chair, that this bill was initially introduced in 2018 and then lapsed. It was, however, reintroduced, Chair, and it was passed by the National Assembly on the 3rd of March, 2020. So it is now under consideration by the Select Committee, Chair.
Thank you. Yeah, that was my understanding. So I was a bit rattled by Honorable Bratteseth's comment. But can we then, in the absence of any other clarity-seeking question, give over to Advocate?
Thanks, Chairperson. I will start with almost the last one, whether the procedure for the appointment of the committee, appeals committee and the regulating committee will be transparent. In fact, that is the gap that we have realized, and we have given the procedure by saying there will be a call for nomination, and people will be nominated, and then there will be a selection process for that. So that is how the process is going to be transparent. So if you look into the content of the bill, that procedure is laid down there. Then we confirm that the process for appointment of the members will be transparent, because it will be the members of the public that will be nominating fit and proper persons to recommending them to the minister for appointment. Here in the bill, regarding the issue of the regulations, or empowering the minister to have regulation-making powers, we realize that there is a gap in terms of the regulations that need to be done by the minister. So we're closing that particular gap by empowering the minister to make those particular regulations. So the minister will be making the regulations which will be clarifying the principal act or this particular amendment act. And the implementers of this act, which is the regulating committee or the appeals committee, will be implementing it, being guided by the regulations, because the regulations tells you how to go about implementing the legislation, not necessarily making the minister the regulator himself. Now, that is not the case. Just to make regulations. The regulations get prepared, drafted, and then the person who approves them and issue them in the Gazette is the minister. So it is in that particular sense. Another question was relating to, yes, it is true that the bills are almost addressing same issues. One would recall that ATNS and AXA are in the same monopoly space, and therefore they are very big interested parties there. That is why we are not even appointing an appeals committee in both bills. The very same appeals committee will be utilized to look into the matters pertaining to AXA and also pertaining to issues relating to ATNS. Then there was a question that was saying, why do we, or what kind of services do you want, or will be these two companies providing, in that we are extending the mandate of the two companies to provide service outside the borders of the Republic. They will be providing the very same service that they are providing in the country. For instance, the air service navigation services, they will be able to provide that even outside the borders of the Republic. Or airports related services, they can also, by means of agreements with other countries, they will be able to provide those kind of services. The issue of for what period will be the appeals committee be appointed, or the regulatory committee? Our approach was that the minister will determine the process, will determine the time period within which are they supposed to serve as appeals committee members. And normally, all our entities, we appoint them for a period of 3 years, with eligibility for appointment for a further period not exceeding 3 years. And what we mean by appointing, if the member vacated his office, the minister may appoint a person for the remainder of the period that was occupied by the initial member who vacates the office. What we mean is, if a member, original member, is appointed for a period of 3 years, and during the second year he vacates the office, obviously that the term of office of that regulating committee is 3 years. Then the remaining period is 1 year. To fill that gap, the minister can appoint a member to fill in, or can appoint a member for the remainder period of that particular year. Because on the third year, we need to run a call for nomination for a full term period of that particular regulating committee, or for that appeals committee. So we are avoiding a situation whereby another member is in his third term, the other member is in his first term. So we are giving a term of 3 years for the whole committee. That is why we are saying, if a member vacates his office on the second term, the minister can appoint a person for a 1 year period to fill the gap for the remainder of a year. Thank you. I'm not sure whether I'm leaving any other one. I might be reminded, but there was another one which was saying, the one that was read out, whether the department will invest. I didn't get the latter part of the question, which was directed to the DM. That talks about the investment, whether the department will invest in something there.
Yeah, you can also check through on the chat group, advocate, just so that there is clarity in terms of the questions that were raised by Honorable Matevula. Subega, can you help the advocate there?
Thank you, Chairperson. The question reads as follows: whether the bill will be open and transparent in making sure that it is this one. Let me just read all of them. Whether the department will invest in expansion of aviation industry and airways in order to encourage more passengers to use air transport. Is it the question?
The second one.
Whether the bill will be open and transparent in making sure that the committee, together with the appeals committee, are appointed in a transparent manner. Those were the questions.
Are you happy, advocate? You are muted.
I'm happy. The second one already. I'm happy, Chair. The second one is already answered.
Okay. Or the issue
by
the
saying
second question. Let's. No, I think you have answered both questions because the other one, the first one says whether the department will invest in the expansion of aviation industry and airways in order to encourage more passengers to use the air transport. That is the first question that the advocate did not get. But I see Pumelela would want to assist. Advocate, that was the first question.
Good day, Chairperson, and all the honorable members and everybody present. Thank you, Chairperson. For me, I think I just was indicating to speak on two issues, Chairperson. I am assisting with the airports company bill, and my colleague Fatima is assisting with the air navigation one. Chairperson, I just wanted to note two things which are basically addition into what Advocate Masombuga has indicated. One being that it is true that the appointment term is not indicated in the Act, even if one looks at the Principal Act in terms of Section 11. However, as Advocate Masombuga indicated, it does state that in terms of the regulations in line with Section 15 of the Principal Act, that can be addressed by the minister via the regulations. And so I'm adding perhaps to say that indication of the 3 years is possibly indicated in the regulation, even though the Act does not speak to it, but it is covered in the regulations and in the manner that Advocate Masombuga had explained. And the other point, Chairperson, which I want to speak to besides the one on the process, which I've already made a note in addition to what my colleague indicated, is I think the first question, which was related to the economic charges and what was the added additional questions that were read now. If one looks at section 11 of the Principal Act as well as 12, which set out, and section 5, functions of the company, which sets out everything that the company is supposed to do. Those provisions in the Principal Act do speak into all those issues that are being raised by members as a matter of concern or not being regulated to. So the principal provisions of the Act, they do cover some of the questions that have been raised. And since these are amendment bills, they are seeking to extend or empower the existing provisions without so much taking away what already exists in the Principal Act. And that is the clarity, Chairperson. Thank you so much.
Thank you. Mepumelela. Any addition, Advocate?
Chairperson, I'm covered by the additions that were given by Advocate Pumelela. I will await if there's any further clarity question. Thank you.
There is a follow-up questions from Honorable Khai. Floor is yours, Honorable Khai.
No, thanks, Chair. Chair, I think when we deliberate after maybe the other processes, we need to have the Principal Act, but also I want to check if the Principal Act has its regulations so that this issue of time period can be clarified, because nobody knows what the regulation will entail after the amendments, the bill has been adopted or made an act. Nobody will know what will be contained in the regulation. So that's why sometimes it's important that some of the issues are better clarified in the act itself, rather than leaving it to the regulation, which you may not participate in its adoption and implementation. So I'm saying for now, maybe we could leave it at such, but as we continue with the process of dealing with this bill, I think perhaps the committee secretary and the committee assistant and the researcher must make sure that we get a copy of a Principal Act. And if the Principal Act has a regulation, we should be provided with the regulation. Obviously, there's no regulation on the appeals because it's a new amendment. Now, I don't know what then would the Advocate Ngema say with regard to that, because all that the Act says, the bill says with regard to that, it's not referring to the regulation, it's referring to the determination. We don't know what does that mean? Would it be in a form of a gazette, or would it be in a regulation? If the minister, for some reason, is not happy with the decision of the appeals committee, you can just disband that appeals committee, because there's no particular period on which they are entitled to. But also this clause I was quoting, it's specific because it says that the remainder of the unexpired portion of the period. Yet there's no period that is specified in the Act. So therefore, it's really confusing to quote something which is related to another a section in the bill, but it's not specified in the bill itself. Because also even that particular clause then should refer to the regulation, not to the expired portion, which is not clarified in the bill. I don't know if I'm making sense, Chair. Thanks.
Thank you, Chair. Advocate?
Chairperson, it makes sense, but that is an operational issue what the honorable member is referring to, because when once a formal transparent process has been run by the minister for the appointment of a board or regulating committee or an appeals committee, the members will be given appointment letters, which will indicate the appointment period. And that appointment period, which will be standing in their appointment letters, will be the term of that particular regulating committee or the appeals committee. Now, out of that particular period, we'll be able to determine as to if a member vacates his membership in his second year, the remainder of the period will be 1 year, because they shall have been, or that committee shall have been appointed for a period of 3 years, if the appointment letters provides as such. So that is the practical operational explanation that I can provide.
Thank you, Advocate. I think the clarity that you have provided.
No, Chair.
Honorable Khai.
Sorry for elaborating on this particular issue, because also the minister, in terms of the appointment letters, must be guided by law. So one minister may appoint these members of committee and give a particular period. Another one may, because there's no law that is guiding them in terms of the time period for the appointment. Unless there's a specific section in the bill that will talk to the issue of the time period, even if it says it will be in the regulation, but it should not just be silent. And therefore, in the regulation, the period then must be specified. Thank you, Chair. Sorry for taking your time on this page.
Maybe just another point, because both documents, both bills makes reference to the approach document and the rationale behind attempting to legalize the approach document. What is the thrust of the two approach document? Are they the same, or what is the situation?
Chairperson, the thrust of the approach document will be the same. It's one similar document operationally for both companies, because it is what has been produced by the regulating committee, guiding its clients, which are companies, on how to lodge their permits applications. Now, this document historically is a significant document, but it was not referred to in the legislation. That is why we refer to it that the regulating committee, through its guiding document called an approach document, might guide companies on how to go about making applications to it. Thank you.
Thank you, Advocate.
Chair.
Tim, Honorable
Chair, thank you, Chair. Chair, I'm fully in support of Honorable Khai in this regard. It does seem to make sense to pass a bill or to agree to a bill that refers to a regulation, and we have no sight of the regulation. So my question is when can we get sight of those regulations, and can specific reference be made to time periods in the bill? I think that is a sticking point, and I think Honourable Khai has perfectly summed it up. Then the other question I forgot to ask earlier, Chair, is that there is talk of an Economic Regulator Act, which will also provide guidance to ministers in general when they are involved in economic regulations. Can advocates or advisors comment on that bill, which apparently is being worked on, the Economic Regulators Act, that will provide guidance in this regard, and how does it affect these two bills? Thank you, Chair. We can't hear you, Chair. You must unmute yourself.
Can't hear you. Can you hear me to yourself?
My humble and sincere apology. Advocate, the floor is yours.
Chairperson, the intention is that all the regulating committees of the department will ultimately be incorporated into the STEP bill. And currently we are in a process of, the STEP bill is in fact introduced in Parliament, and it will reach the select committee so that you can see as to how is it going to synchronize with this particular legislation. But the aim of STER, it will be to synchronize all regulating committees so that there can be one regulating committee for the transport industry. Thank you.
Thank you, Advocate. DM?
Thank you, Chairperson, and thank you to members of the committee. I think it's very important, the questions that the committee has raised, and we believe that as we shall be dealing with the regulations, we will be able to factor in some of the things that you have raised in this regard. But I would like to thank the portfolio, the select committee, I'm sorry, always thinking of the portfolio committee, the select committee, that indeed for us to come up with these amendments are the amendments that we have looked into, which actually will be able to make the two entities be able to have business sense as they are dealing with business. Let me indicate that, honorable members, probably you may be aware that Airports Company has been doing businesses in Ghana, in Brazil, in India, and there has never been legislation which actually regulates that. And that is the reason why we're saying we need to have the law that can be able to regulate how these state-owned companies, when they go international, what are the things that we should be able to look at, and what are the things that we should be able to guard against, particularly in the eventuality there are problems, whether they are having businesses which actually are having challenges. How do we deal with the situation? Hence, this approach that we're having, but also to indicate that we should take into cognizance the fact that traffic and navigation, we control 10% of the space in the Southern Hemisphere, and therefore it is very important that as we're dealing with that, Africa in the main depend on how we're doing things here in the Southern African space, but also we need to work on how best can we be able to maximize revenue generation outside of South Africa, if needs be, in Africa and the world as a whole, where we can be able to have our traces and steps into. It is very important for us in this instant, particularly in the aviation industry, that we become competitive in Africa, but also competitive in the world. And Chairperson, I would really want to appreciate the level of engagement by the select committee, and we're looking forward to, once we have been able to come with the regulations, we should be able to give the regulations to the select committee, for members of the select committee to acquaint themselves with how this is going to be happening. Thank you very much, Chairperson.
Thank you, Deputy Minister, for those concluding remarks. I think as the select committee, we set ourselves right at the beginning of the meeting to say today's meeting is to get a briefing from the department on the 2X, and with the Air Traffic and Navigation Services Companies Amendment Bill, the team led by the Deputy Minister was able to clearly outline the thrust of the bill, why the need for a bill in terms of strengthening the appeal mechanisms, but also to ensure that there are certain documents that are given legal status. But more than that, to ensure that there is an alignment between the Principal Act and the Companies Act, and challenges also were put forward in terms of what are the limitations with regard to the Principal Act, and the DM and the advocate were able to also give to us in a precise manner what are the key features of the bill, and I want to believe that members have indeed expressed the appreciation of the proposed amendment, and therefore also we are happy with the manner in which the department was able to engage with the stakeholders, but likewise also with the airports company. As the meeting, we had the benefit to also get the gist of the challenges that more or less are the same between both the ANS and also the airports company, and the need to ensure that the arm of the executive authority is strengthened in terms of the regulation, but also with dealing with appeals, and we are looking forward to taking this process to its logical conclusion. Now that there is much more clarity in terms of the letter and spirit of the bill, and we are mindful of the fact that as indicated, the matter has been finalized by the National Assembly, and we will then ensure that in the next meeting of the committee, we will then be able to deal with the report of this meeting, so that we prepare ourselves for taking the two bills to the plenary. And on those words, Honorable Deputy Minister, your delegation, and also the Honorable members of this select committee, committee secretary, and also the researcher, I want to formally express my appreciation on behalf of the select committee for your attendance of this meeting, and that indeed it was an educative session. It was an eye-opener. We were able to appreciate the complexities that the two principal act has posed to the situation, and therefore the manner in which the department is proposing to remedy those challenges. And with those a few words, honorable members, the DM and the team, this brings us to the end of the meeting, and the meeting is now adjourned. And have a wonderful afternoon. Continue with the good work that you are doing. Thank you, honorable members. The meeting is now adjourned.
Thank you, Chair.